Appeal in the matter of CMG Pension Trustees Ltd and CGI IT UK Ltd and another.
Yes.
May it please your lordship and your ladyships, I appear with my learned friend Mr Ashdown for the appellant, the pensions ombudsman, who is a statutory commissioner appointed to exercise certain functions relating to pension schemes. The current pensions ombudsman is Mr Dominic Harris, who took over in January of this year from Mr Anthony Arter, who was the ombudsman at the time permission to appeal was sought. My learned friend Mr Short appears with my learned friend Ms Grace for the first respondent, who is the sole trustee of an occupational pension scheme known as the CMG UK Pension Scheme. The second respondent, which is the sponsoring employer of the scheme, isn't represented and isn't actively participating in this appeal. This is an appeal from the order of Miss Justice Leach, dated the 12th of August 2022, on one part of the last of 9 issues that he was asked to deal with in a Part 8 claim brought by the trustee. And the context of the claim was the discovery by the trustee that members' benefits had been historically underpaid, and the correction of those underpayments were made between 2016 and 2019. Many of the benefits that were corrected, perhaps I should pause, there seems to be a bit of an interference. I don't know if that's me.
It does happen, actually it happened the other day.
I'm happy to bat on if your lordship, your ladyship, sir.
Carry on.
May I also, I do apologise, see if one puts one's finger on the button, whether one can get a little bit more light, because you are quite dingy.
Yes.
I think
That's not the light.
Yes, that is right.
Now.
I think there's one set of lights that failed last week, and they have yet to, of course, replace them, because the man who replaces them has to come from Carlisle or wherever.
I'll endeavour to shed as much light as I can from this side of the bench.
So members' benefits were underpaid.
Yes, they were underpaid, and then they were corrected over a period of time. And many of the benefits that were corrected had fallen due for payment many years before before the problems were discovered. And an issue that subsequently arose was whether a provision in the scheme rules which forfeited benefits which hadn't been claimed within 6 years of the date of payment, whether that provision applied to these payments. The issues that the judge had to deal with are set out at the end of his judgment, beginning at paragraph 161. I don't intend to take
judgment is focused on that Rule 511 point.
That's correct, my lord. 8 of the 9 questions related to the construction, the operation of Rule 5.11, and the 9th only arose if the forfeiture rule was applicable to corrective payments, because in that case the trustee had to consider the exercise of its equitable right to recoup overpaid pension benefits out of future pension instalments. And as the judge held that the forfeiture rule did apply in that situation, and so the affected members had been overpaid, the 9th issue arose for determination, which concerned the scope of these statutory limitations imposed on the right of recoupment. The 9th issue is set out on the final page of the judgment, and it raised 3 questions, and it's the last of those questions that's the subject of this appeal, whether the Pensions Ombudsman is a competent court for the purposes of section 91(6) of the 1995 Act. Now, your lordship and your ladyships would have seen from the judgment that the judge held that the Ombudsman was not a competent court for those purposes, on the basis that that issue was part of the ratio of Mr Justice Arnold's decision in an earlier case called Burgess and Bick, and the learned judge wasn't satisfied that that decision was wrong and so oughtn't to be followed. The Ombudsman wasn't a party to the claim, and perhaps surprisingly, no attempt was made by the parties to notify the Ombudsman of the claim and of the fact that an issue in it directly affected his statutory function. After judgment was handed down, neither of the parties sought permission to appeal, but after being notified of the judgment and having taken external legal advice, the Ombudsman applied to the Court of Appeal for permission to intervene in the claim and to appeal, and those applications were granted by Lord Justice Lewison on the 23rd of February. Now, this appeal involves a short point of statutory construction, so I propose to start by looking quickly, if I may, at the relevant statutory provisions. The first is section 91 of the Pensions Act 1995, which is in the Authorities Bundle, first volume of the Authorities Bundle, tab 2, page 28. As your Lordship and your Ladyships are doubtless familiar with the provision, I don't propose to read it out in full, but I will, if I may, make a few introductory points about it. Firstly, the prohibition on alienation of benefits in subsection 1 includes, at A and B of subsection 1, charges, liens and set-offs. And the exception to the prohibition which we're concerned with, which is over the page on 29, it's subsection 5F.
Yeah.
Your Lordship and your Ladyships will see that that relates to charges, liens and set-offs. It was common ground in the court below that the trustee's equitable right of recoupment comes within the scope of those provisions, and the Pensions Ombudsman doesn't contend to the contrary on this appeal. Moving to section 91(6), we make 3 points on that at this stage. Firstly, the requirement for an order of a competent court is not necessary in all cases of recoupment. It's only required where there is a dispute about the amount of the sum which is sought to be recouped. And we submit it follows that the purpose of the requirement for an order of a competent court is clear. It is to protect the member from being deprived of any pension benefit where there is a dispute as to the amount to be deducted, unless that dispute is effectively resolved.
Yeah.
Our second point is that the effective resolution of the dispute doesn't have to come from a competent court. It can be resolved by an award of an arbitrator.
Yeah.
Our third point concerns the use of the word enforceable in this context. In this context, the reference to enforceable has to be read in the light of the fact that recoupment is a self-help remedy, which doesn't require the member actively to do anything. Recoupment is where the trustee takes the money owed out of pension instalments, out of assets in the trustee's own hands. So the member doesn't have to do anything.
But it would mean, wouldn't it, that the trustee, what it means surely is that the trustee can't exercise the right of set-off.
That's exactly right.
So,
That's exactly right.
must not be exercised unless the obligation in question has become enforceable. So the issue in question, I suppose, is well, it's not really an obligation, is it? It's a right of set-off.
Well,
I suppose.
What the judge said below is that...
Sorry, just a moment. Can I just ask the Usher, could you possibly get on to Wilf and say, could he send somebody here to sort out the noises coming out of the speakers? Thank you.
Given the fact that a member isn't under any monetary obligation to the trustee by reason of under this remedy, what the learned judge said below at paragraph 151 of the judgment...
Try turning that microphone away from
this one, Lord.
that one, yeah. That may be
It sounds more like it's interfering with something.
When you speak, it feels like this. It's that microphone might be defective. Just try. I wonder if you might try a different microphone.
This one?
Why don't we switch them off for a moment?
Can we switch them off? Have they got an off switch on them?
We can. We have an off switch.
Try switching them off.
I've just switched mine off and it's miraculously stopped.
Perfect.
No.
I don't know whether we can switch them off.
Okay.
It seems much better.
Yes, should we all switch ours off?
Yeah, I think that may be what the issue is.
No.
Somebody's microphone is interfering. One of those microphones down there. I'm sorry, I don't know which one it is. Is there an off switch on it?
I don't think we've got the off switch. Oh, Liz.
Learned Junior may have done the trick. Who knows? Well, I'll take advantage of that and carry on.
Let's keep going,
if I may.
Right.
We were talking about the fact that because the member isn't under any monetary obligation to the trustee, there's nothing to enforce against the member. And what the learned judge said below was that in that situation, what the member's obligation is to give effect to the remedy. which we read as meaning simply in the sense of to suffer their future pension to be reduced.
Reduced by the recoupment amount.
Exactly,
That's correct.
nothing more than that. So it's an entirely passive a feature of the remedy. And what the judge said below at paragraph 152 of the judgment is that it's sufficient for the trustee to satisfy a competent court that it's entitled to exercise the right of recoupment. That was the words he used. And in that context, we submit that the obligation becomes enforceable when the trustee obtains an order from a competent court that requires the member to give effect to the remedy. In other words, requires the member to suffer the remedy happening to his pension benefits. And that's really what enforceable really has to mean in this context.
You can see, I just want to reel back a little bit.
Of course.
In this case and others, the predicate is, I think, that the pension ombudsman has determined a dispute that has arisen between the trustee and the member about whether the recoupment can take place and over what period and in what amounts and so
Whether
on.
any defences,
So
etc.
we have, I think, in fact and hypothetically, a determination
Yes.
and probably directions as well.
Yes.
We know, don't we, from section 151, I think it's sub 5, of the other Act, that that determination is enforceable as if it were an order of the county court, which is a statutory fiction saying it is an order of the county court. So why do you need anything at all? Why don't you just go straight into 91.6 and say the obligation in question has become enforceable? Indeed it has, under an order. Well, it may be a statutory fiction that it's an order, but the county court is seized of it. So the competent court here is the county court. It's nothing to do with the PO. It's the county court that can enforce the previous decision of the PO, and then that.
Well,
I mean, it doesn't seem to be the point that anybody's
enforceable,
taken.
which is become enforceable, suggests it's something which has already taken place, and that's why, like my lady, I go back to section 1515 of the 93 Act, which contemplates that you get a determination from the pensions ombudsman, and you then go to the county court. I mean, we wondered what the process was.
Well,
you go to the county court and you say, here's a determination of the pensions ombudsman. Now please rubber stamp it as an order of the county court. And that's what the section contemplates.
That is the consequence of the trustee's argument in this case. That because because the pension ombudsman is not the competent court, and you're right, my friend doesn't identify what the competent court is, but let's assume that, I mean, obviously, on a matter of enforcement, once we're in the county court would fall
It's
within
only
the
a rubber
definition of
stamping
competent court.
exercise, isn't it? Because
I'm sorry, Lord.
it's only a rubber stamping exercise because the determination by the pensions ombudsman is final and binding.
Yes, well,
Unless
that's, and I'm absolutely coming
on
on.
anything before the county court other than say, please make an order.
Well, I'm coming on to that, and your lordship is entirely right that there is nothing for the county court to do, and one of the submissions I'm going to be making is that is not a construction which requires the trustees, having got a binding determination, having to deal with all the issues, still having then to initiate fresh proceedings in the county court, is a waste of time and is an absurd result.
But if I may cut to the chase on the sort of analysis we're looking at, so the way I have to confess I read 91.6 when I came to it as an outsider, not as a pension specialist. It would meet your concern that the pension ombudsman must really have the final word, and once he's settled the case, once he's made his determination, his or her determination, that's it. All there is enforcement in the county court. So it would meet the bigger point, but on the small, narrow technical point before this court, it would mean that the competent court is the county court, because that's the court charged with enforcement. So I really just float that.
Yes.
It seems to me that's a reasonable and a rational way of reading this provision.
In the context of enforcement proceedings where there is an obligation on the member, there's a monetary. So let's assume that we're not looking at recoupment, but we're looking at a charge over the member's pension benefits. If that charge is made and the determination is binding, is that a determination is made in the pension ombudsman with regards to that charge, then clearly it is perfectly possible that enforcement proceedings may be necessary by the trustee if one has a recalcitrant member who refuses to meet the charge. And there, the county court has something to do.
Yeah.
The county court may have to use its enforcement methods in order to force.
So, yeah, I'm sorry to interrupt you. So first of all, you accept that in those circumstances under 151, it would be the county court who would be doing the enforcement. I don't think that's
Yes.
in doubt.
Yes.
And that in those circumstances also, just so that we know which page we're on, the determination of the pensions ombudsman is a determination, it's binding on the parties to it, and all that the county court is doing is enforcing that order, as 1515 says, as if it were an order of that court.
Yes.
It's just as if the county court had made a decision and an order, and then it needed to be enforced in just the same way it enforces the pensions ombudsman's determination.
Exactly.
Exactly.
But what we're looking at here is not enforcement in that sense. We're looking at enforcement of the underlying legal obligation.
So far as the beneficiary is concerned, it's an entirely passive situation
Exactly.
where it is just done unto them, and there's nothing. Well, the trustee is enforcing, actually.
Well, the trustee is enforcing in the sense that they have to go to court in order to get a piece of paper which then satisfies section 91.6 if that's the proper construction of section 91.6. The trustee's not doing anything at all because the ombudsman has already made a binding determination that they're entitled to recoup, the amount of recoupment, the rate of recoupment. There is nothing for the county court to do. It is a futile, pointless trip to the county court.
Well, I'm not so sure about that. The pensions ombudsman makes the determination, the effect of which is the right of set-off. And what subsection 6 is saying is you can't exercise that right of set-off unless you've got an order from the county court saying that the obligation, the underlying obligation, is enforceable. And that construction reflects section 1515 of the 93 Act.
And you may not actually even need an order, which is why I want to know what actually happens, nuts and bolts, in the county court if you turn up with a ruling from the pension ombudsman. Because you could read section 1515 as a fiction that says you've already got an order, because it's as if there is an order of the county court already in existence because of the PO's determination.
Well,
so there is an issue there about what actually happens.
Yes, I do that. If I could go back to my Lord's question. Your Lordship said that section 91.6 is, it says that the county court is the competent court. That, with respect, is the issue that we're dealing with.
I know, but all I'm saying is if it is if you try and read the two, try and make sense of the legislation as a whole. I mean, it's badly drafted, like almost every other piece of legislation we ever have to look at. But because you can rightly say, well, a charge or a lien on one hand is enforceable in a way in which a set-off isn't, because it's on one view, it's a right of self-help.
Yes.
But what this is really saying is, well, you can't exercise that right of self-help unless...
But the problems we're seeking to... the practical problems of having to go to court to the county court, with the county court has nothing to do, and the problems we're seeking to deal with would, in our submission, and the purpose of section 91.6 in our submission, which, as I say, is to protect the member where there was just dispute of the amount, would be fulfilled if your Lordship was to hold that the competent court for section 91.6 purposes is not only the county court, but also the pensions ombudsman. Now, it may mean that in cases where there is a monetary obligation on the member, where there is a need to enforce, where there is a purpose in enforcing, then the trustees have to go to the county court for enforcement. But in our submission, section 91.6 only arises in circumstances where there is a need to enforce. But
It talks about enforceable. It doesn't say enforced.
But it
must
says-
be enforced.
But it says you can't exercise.
Dispute as to that.
You can't
Set
exercise.
off, but we're in F. Everybody's agreed we're a section 91.5F case. So we've got a set off problem. And 6 tells us that the set off must not be exercised, even your equitable, internal, self-helpy kind of set-off, mustn't be exercised unless the obligation in question, in other words, the beneficiary's obligation to let the trustee or the payer take a chunk out of their pension, has become enforceable.
Yes.
It is amenable to enforcement under an order of a competent court. So the issue is the sort of self-help set-off type determination by the PO something that is enforceable under an order of a competent court? And for my part, I don't see that. I think the answer for my part lies in section 151, and we might want to look at that.
Yes.
You may not need to go anywhere near the county court. It's not asking, have you been to the county court, or do you want to go to the county court? It's saying, is it enforceable in the county court? Answer, yes.
Because it is a binding determination
I-
or direction.
I see. So it is sufficient in order that the Ombudsman is a competent court, because the Ombudsman has. I'm sorry, I've misunderstood my lady's point.
As my lady says, section 151
Yes.
creates a form of fiction that says that it's enforceable as if it were an order of the court. Now, there's an issue as to what you have to do vis-a-vis the county court, I suppose, and we don't know, and nobody seems to have looked at it. I'm not criticising, but nobody does seem to have looked at it. But the point we're making about, when you then go to section 91(6), is section 91, and you ask yourself the question, has the obligation in question, the right of set-off, become enforceable under an order of the county court? The answer is yes, because the Pension Ombudsman has made a final and binding determination which could be enforced. In other words, the whole argument is really entirely circular.
Well, there is an additional problem with that analysis, which is one that we've raised as an alternative in our skeleton, which is that the section 91(6) only comes into play if there's a dispute as to the amount. And of course, there is a dispute when it comes before the Pensions Ombudsman.
Yeah.
But the dispute is effectively terminated and dealt with by the determination of the Ombudsman, because the Ombudsman has the jurisdiction to deal with the issue, and the determination is final and binding on the parties, in which case you never get into section 91(6), and therefore it is irrelevant whether the Ombudsman is a competent court for these purposes.
I can see that, because you'd say there is no dispute. There has been a dispute which has been concluded.
Yes, so there is no dispute. So the gateway for the applicability of section 91(6) doesn't arise.
To the dispute, the Ombudsman makes the determination, and that's sufficient to trigger those, that, as it were, proviso to 6. But it's got nothing to do with the Ombudsman being a competent court. It's to do with the fact that the order would be an order which was, the determination of the Ombudsman would be an order, have the effect of, as if it were an order of the county court. That's what
the point I'm making is that section 91(6) only arises, quote, where there is a dispute.
Yeah.
Okay. The dispute arises by way of the member making the complaint to the Ombudsman. The Ombudsman's determination resolves the dispute, and it's binding on final on the parties.
Yeah.
So therefore there is no dispute for the purposes of section 91(6).
Oh, I follow.
So there is no need for an order of the competent court in order for the trustees to be able to recoup.
I wondered about that, and I can see the argument that the present tense is significant there.
Yes. Yes.
But I have to say my response to it was that, as a matter of practicality, you may well be dealing with a dissatisfied beneficiary who may not appreciate the legal technicalities, might say, but I don't think the Pensions Ombudsman got it right, so there is a dispute, and then this heads it off by saying,
But in that situation, my lady, the answer is not enforcement, it's not going to the county court, it's an appeal. The fact that it's final and binding on the parties is subject to the fact that the parties have a right to appeal on a point of law to the High Court. And that's where you deal with it. Now, in that situation, if the High Court says appeal dismissed, for example, that surely is an order of the competent court. But one has to step back and say, what's the point of all of this? What additional protection are you giving to a member whose rights have been conclusively determined by the determination of the Ombudsman. And the whole purpose in our submission of Section 91.6 is to protect the member where there is a bona fide dispute. And if the Ombudsman has resolved it against the member might be dissatisfied, but the answer isn't then to require the trustee to go off to the county court, because A, the county court can't do anything, and B, where the member goes is appeal.
Because I have to say, I'm not sure I would accept the predicate that anybody's requiring anybody to go anywhere near the county court. And I would agree with you, for what it's worth, that the purpose of 6 is protective. It's to protect the beneficiary, typically, and to make sure that before there's any set-off, they are, in my language, appeal rights exhausted.
Yes, absolutely.
It's happened, it's finished, and it's now enforceable in a competent court.
Absolutely, but if it's the case that the member has complained to the Ombudsman, and the Ombudsman is determined against the member and for the trustee, and the member decides not to appeal or doesn't get permission to appeal, then it's cede quaestio. That is the end of the dispute. There is no dispute for the purpose of Section 91.6. And you don't even get into the question of whether you need to have an order of the competent court or for it to be treated as enforceable by reason of the statutory fiction in Section 1515.
But could you just go through, I follow what you're saying about the dispute and whether there is a dispute, and that in the perhaps the normal scenario, that dispute will have been determined by the Pensions Ombudsman, and then you say at that stage you're not in 91.6 because there's no dispute. When does 91.6 actually bite then on that analysis?
It doesn't, well, on that analysis, it would bite if, for example, the member hadn't complained to the Ombudsman. The member hadn't complained to the Ombudsman.
And there is an open sore of a dispute. Yes.
Yes, but then that's the question. If the member hasn't complained to the Ombudsman, where's the dispute?
Yeah.
The dispute has to manifest itself in some procedural way. So that doesn't work. That doesn't work either. So I'm working it through
Precisely,
myself.
so that's why I'm trying to work out if the analysis is right that there is no dispute now because it's been resolved by the Pensions Ombudsman. So you're not within 91.6, which is what you were saying. When is there a dispute which 91.6 applies to? I'm just being slow. That's all.
There is a.
Because you're saying, first of all, if there's no complaint to the Ombudsman, you may just have a disgruntled member, but you haven't got a dispute.
Yes.
And then you're saying, if he does complain to the Ombudsman, then your point was 91.6 doesn't bite in the circumstances that we're in, because then you would have a determination, which means that the dispute is resolved, and so you say you're outside 91.6.
Yes.
So I'm still
Yes.
searching for when
Yes.
91.6 works.
It goes back to my lady's open sore point. So the member, having been notified by the trustee that they want to exercise right of consent, said no, I don't accept that. And the trustee says, well, we're going to do it. The member has got two choices. The member can make a complaint to the Ombudsman. Well, three choices. They can make a complaint to the Ombudsman. They could bring proceedings in court, but they're very unlikely to do that, given the Ombudsman is obviously the most appropriate means for resolving that dispute. Or they could do nothing. And they could then force the trustee to say, well, you've got to do something in that situation. In that situation, there is a dispute.
There is a
There
dispute,
remains a
and
dispute.
the trustee can't go to the Ombudsman, so the trustee has to go to the court.
Exactly. Yes. Exactly. Now, if that's not correct, and and I come back to the 2 points I've made during the discussion with your Lordship, your Ladyships, is that there are two key principles underlying our submission that whether by our first route that we've submitted that the Pensions Ombudsman is a competent court, or by the second route that there's no dispute in these circumstances, there is no policy reason whatsoever for construing this provision to require the trustee to do anything more, having obtained, or there having been a binding determination of the Pensions Ombudsman. There simply is no point. Now, we're not going to be able to get into the question of what happens by means of enforcement, what needs to be done in order to enforce, but there is certainly a issue. And I take my Lady Justice Whipple's point about whether or not the statutory fiction is sufficient to avoid having to do this. But there is an issue as to whether in that situation the trustee would have to apply to the county court for an order, and it would be, as my Lord the Chancellor said, a rubber stamping order, because there's nothing for the court to do. In that situation, how is the policy purpose of Section 91(6), which is to protect the members from an adverse order being made against them where there is a dispute, without an effective resolution of that dispute happening? How would it further protect members? And secondly, as I've already said, what if one was to construe 91(6) as to require the Ombudsman, the trustees to go to court, then given the fact that the determination is final and binding on them, there's nothing for that court to do, and it would be an example, particularly egregious example, we would say, of the court acting in vain, requiring pointless litigation to be brought. But I do take my Lady Whipple's point about there is a question as to whether or not.
I'm afraid I think we really need to get into the weeds of working out what exactly happens on the ground, because that may be what we need to decide is how it all goes.
The problem
the
is
classic scenario where this, I mean, in a sense, forget the facts of this case. The classic scenario surely is this, isn't it? The trustee determines that there's been an overpayment. In this instance, there's been an overpayment because there was a right of forfeiture that hadn't previously been exercised under Rule 511.
yes.
So the trustee says to the members, "We are going to recoup 45% of your of what you got paid over the last 5 years," and that's a right of set off. This is saying you can't exercise that right of set off where there's a dispute.
Yes.
Unless something happens.
Yes.
So the trustee says that's what we're going to do, and the members say we don't accept that. We don't agree with you about that. It shouldn't be 45%. It should be 35%. Whatever. So in that scenario, there has to be that the underlying obligation. The obligation in question is the one that's referred to, as I read it, in 5F. That's to say, the obligation of the member to repay.
Yes.
Because he's been overpaid. And so the obligation in question has to become enforceable under an order of competent court.
He's not repaying, my Lord. It's being recouped out of.
It's money that's due from him, technically.
Due to him. Yes, it's being taken out of money that's being due.
Precisely.
Yes.
So, in other words, this is saying, where there's a dispute, you, the trustee, can't enforce the right of set-off unless there's an order of a competent court.
Yes. And
the question then is, well, if it's all before the Pensions Ombudsman, is what the Pensions Ombudsman determines an order of a competent court? If it's before the High Court, then there's not a problem. The High Court makes a ruling, there's an order of the competent court.
But the question then, my Lord, is what happens when the Ombudsman issues a determination that's final and binding that resolves the dispute?
Yeah, I understand the point.
Then there is no dispute. So you don't even get into the question of competent court in that situation because the gateway to Section 91(6) has not been triggered.
It's a very peculiar reading of 91(6) because you'd have a present tense where there is a dispute. So you'd be asking yourself, is there, as I stand here in front of you now, a dispute?
I suppose
and then they say that if there is a dispute, you can't exercise the set-off unless the obligation in question has become enforceable, the predicate of which is the dispute has been resolved. So in other words, there's a bit of a tension in the language.
But if one looks at the purpose of the provision, the purpose is to ensure that the member does not have a disputed amount recouped from his benefits, unadjudicated, and it has been adjudicated.
Yeah,
so the construction that I'm putting forward, it's not a strained construction because of the present tense where there is a dispute. You need to ask yourself at the time you're seeking to exercise that right, is there still a dispute? And the answer is no, because there's a final binding determination of the court. And the policy reason behind it is fulfilled because the member's dispute has been dealt with. The member has got his protection by having the process of the Ombudsman's investigation and determination of his issue dealt with, which by legislation is final and binding on him.
Yeah, and which he's chosen not to appeal. He has a right of appeal, but he's chosen not to. So
Yes.
there you are. His
Yes.
appeal rights exhausted.
And it has to be remembered, my lord and ladies, that the reason why the member might have complained to the Ombudsman is not simply because they may have been concerned about the amount of the recoupment, which is the gateway for Section 91(6). There are other reasons why they may want to complain about the right of recoupment being exercised in that situation. They may dispute that the pension benefits have been overpaid in the first place. There may be an issue of fact or an issue of law as to whether or not they have been overpaid. There may be defences to the right of recoupment. The classic one being change of position, which is raised all the time. The overpayment I got, I've used to buy a yacht or buy a house, what have you, and therefore it's been overpaid. Those issues would be issues that the member would want to have determined, and would want to have determined by the Ombudsman. The Ombudsman is the obvious place to bring those complaints. It's cost-free. It's obviously a very specialised and experienced forum for the resolution of these disputes. And the consequences are that we have all those issues dealt with, and the member has had all their complaints argued out, considered, investigated, satisfied and determined. That's the end of it. There's no need to go into Section 91(6) in that situation.
And why, in those circumstances, and of course, in cases like this, there are many facets and many questions which are resolved in relation to a dispute about overpayment. As you say, they may have gone on a world cruise or whatever, all those issues. And one ends up with probably with a determination and directions.
Yes.
In the same way, 151, the Pension Schemes Act, 1515 says, any determination or direction shall be enforceable, as we know, in A, in the county court, as if it were a judgment or order of that court.
Yes.
Now, you accepted earlier, I think, that outside this rarefied atmosphere of Section 91, there would be determinations and directions for which 1515A would apply, and that in order to enforce, you'd need a rubber stamp from the county court who would receive the determination and treat it in the same way as if it were an order of the county court, and therefore set forth the enforcement routine, put it like that. Now, if that is the case, what is the real difference, and why should it be different when one has the kind of wording that one has in 91(6)? Why should it be different when the determination or the direction relates to a set-off? Because that's what you're saying. You're saying in relation to usual determinations, usual, not set-offs and all those other things, charges and liens, you're in 1515, and that says, plain as Pikestaff, that you need an order of the county court to enforce. But you're saying, if we're in the rarefied atmosphere of set-off, etc., in 91, you don't.
Yeah.
That's what you're saying, and you're saying that because, I think you're saying that because this is passive rather than positive, in the sense that nothing actually physically has to be done, the pensioner just gets less. But that's might I say, at the moment where I'm thinking at the moment, a very slim branch to make the difference.
Well, of course, Section 91 and 91(6) relate to matters that go well beyond the Ombudsman.
Yes.
And what the Ombudsman does...
Well, does it? Because there's also authority that the Ombudsman can decide about fraud and various other stuff.
Yes.
She says, generally.
What I'm meaning is that Section 91 is not specifically directed, specifically and only directed at the Ombudsman jurisdiction. But that's what I'm
No,
making.
that's plainly right. It feeds in from the criminal jurisdiction
Yes.
and the general civil
Yeah.
jurisdiction
Yes.
as well
Yes.
as the PO
Yes.
jurisdiction.
And of course, the Ombudsman is simply directing what the trustees do in that situation. And what the Bick and Burgess case said is that is sufficient. It's sufficient for them to declare what's happening. There is no enforcement in that situation. There is no enforcement. In fact, my instructing solicitors who have much more experience of the Ombudsman's process than I have tell me that in practically what happens in a situation where a determination is made in favour of, let's say, the trustee. The trustee simply sends the form to the county court along with a fee and a certified copy of the determination, and the county court stamps and orders it without any more.
There we are.
Yeah.
But
that reflects the fact that there is nothing for the county court to do because there is no dispute.
There is, though, because section 1515 actually says in terms that it's enforceable by an order of the county court, as if it were an order of the county court. So you do need, ultimately, maybe nobody bothers about it, but ultimately you need that court stamp on the order before the thing is technically enforceable.
Well,
that's the point about section 1515. And speaking for myself, I still don't see why, when we come and look at section 91.6, it's not the same process.
And I don't really understand what the problem is for the pension ombudsman. I mean, your skeleton, I was just looking at it again, and all the rubric that we've had. The worry is that you might reopen the whole can of worms at this stage, and that's not right. You obviously can't reopen it.
You may say that's not right, my lady, but that's what the trustee is saying. The trustee in its submissions is saying that a determination of the ombudsman is not res judicata.
Nothing. No,
Yeah,
okay.
despite the fact of section 1513 that it is possible that the whole can of worms can be reopened, and it's that kind of worry that's
But I
caused
get
the
that.
ombudsman to be here.
I completely understand.
Because-
I just wonder if we're all tilting at the wrong windmill, because the issue about whether it's a competent court or not perhaps doesn't matter nearly so much as the issue about the reopening and whether the pension ombudsman, by their determination, effectively settles the
Well,
dispute.
that's the windmill I've moved to.
Those are
It's
the earlier
final and
legal
binding.
questions.
I'm happy
It's
to...
final and binding.
It's final and binding. I mean, what are the words final and binding mean?
Well, you'll have to ask my learned friend about that. It's not my submission, it's my learned friend's
Speaking
submission.
for myself, the moment I saw that, I thought res judicata. I went and looked at the latest edition of Spencer, Bower and Handley, which I haven't brought, but it's paragraph 205, which says in terms, actually in the context of disciplinary tribunals, it says that the determinations by disciplinary tribunals give rise to res judicata, where they're final and binding, which they clearly are.
Yes, with
And
respect...
that's same position as here.
Your Lordship's pushing an open door with me, and I'm sure your Lordship's points are being perhaps made more to my learned friend than they are to me.
No, it is.
But is that, it's those kinds of concerns that because if section 91.6 does require the ombudsman, the ombudsman to do this, that means that the gateway has been triggered. That means there still is a dispute, and there is a concern about finality. And we respectfully completely agree with your Lordship about what section 1513 means.
If this court were to say section 91.6 does require there to be an order of the county court rubber stamping the determination by the pensions ombudsman, but the pensions ombudsman determination is final and binding, and where there isn't an appeal is a res judicata, then you could presumably go away happy, could you? You might need to take instructions.
And of course, I may have been over egging the pudding when I gave your Lordship and your Ladyships the normal process when it came to how enforcement is dealt with. In the vast majority of cases, there isn't any need for enforcement. The vast majority of cases, the member simply accepts what the Ombudsman has said and decides not to appeal in that situation, and that's the end of it. Then the trustee goes on to recoup. But we are here. We have a concern about whether section 91, precisely what it is that section 91.6 requires the trustee to do. And also we have a particular concern about what the status of the Ombudsman's determinations are in circumstances where section 91.6 might apply, because section 91.6 requires there to be a current existing dispute. We think that the dispute is dealt with after the determination is issued, and therefore you don't get into section 91.6 and this issue goes away.
I didn't find that. Just help. I didn't find that in your skeleton anyway. Was I missing that one? But it was in there.
It's issue 9 of our grounds of appeal,
Okay, so that's fine. Thank you
and
very
it's
much.
paragraph 68 of our skeleton,
Thank you
lady.
very much. That's great. Thank you.
All right.
Thank you. I interrupted you, I'm so sorry.
I'm sorry, if I could just have a word with my learned unit.
68.
So you say it's only if there is a current dispute of whatever sort or nature, it's only in those circumstances that there needs to be enforceability under order of a competent court.
Is where there is a dispute. But we say the words mean what they say. And is there a dispute? And ask yourself the question when a determination has been issued and the trustee comes to recoup, is there a dispute? Answer no. Therefore, you don't get into section 91.6. And you may say, well, that's odd in that situation, but we've already identified a situation in which section 91.6 would apply where there was a dispute in circumstances where the member had notified the trustee that they weren't happy with the situation but decided for whatever reason not to go to the ombudsman. In that case, the trustee would have to get an order of the competent court because there would still be an outstanding dispute. And also go back to the point that to decide otherwise would be to be inconsistent with the policy underlying, in our submission, underlying section 91.6 because the member's position would have been protected by the reason of termination, and it would avoid the practical consequences of there being at least a doubt as to what might happen with regards to enforcement after a determination.
There wouldn't be any doubt, would there, though? If you get it, if that is necessary, and putting aside whether there's a dispute question, you get a determination, it's final and binding, and there's the issue about whether has become enforceable is sufficient because it has become enforceable even though you haven't done it yet. So that's another argument on one side. But even if you don't take that view, you've got a final and binding determination. 1515 says the way you enforce that is by a rubber stamp in the county court. There's no doubt, even if that is the final route,
Yes.
and perhaps the worst, as far as you're concerned, route. But there would be no doubt.
Yes, your Lordship's right. As far as the Ombudsman is concerned, if the Ombudsman could be satisfied that its determination was final and the end of it subject to an appeal, and in that situation, given the circumstances on the ground that either enforcement isn't necessary or enforcement is a rubber stamp in that situation, then subject to me taking instructions, that may be sufficient for us. But as we're here...
It might say, I mean, as we're here, so there may be other arguments, but the PO might say, look, it's a belt and braces, but if all we need to do is send the determination to the county court with a letter saying, please rubber stamp, that's not a lot to do to perfect this system, which is set out in 2 statutes, and get it home.
Well, yes, I mean, yes, but if it's possible to avoid the situation where trustees perhaps of pension schemes that are in deficit are still having to pay money and a court fee in order to do this, and also get the member involved as well. The member might have thought, I've gone to the Ombudsman, it's all being done in a relatively informal manner, it's all cheap, now I'm being embroiled in court proceedings, what am I going to do? There are worries there.
You're not. I mean, you're instructing solicitors, your instructions, which you told us a moment ago, is that what happens is if there's a form which goes to the county court looks at the form, looks at the decision of the pension ombudsman, and simply rubber stamps the order. So it's not the member doesn't have any involvement at all. It's the ombudsman who's enforcing it.
There is still the fact that it is a piece of
member's favour. He might be seeking to enforce it, yes, but it's not exactly arduous, is it?
We still come to the point that why is it necessary to make the trustee go through the rigmarole of having to do this in circumstances where in our submission there is an alternative construction that avoids the necessity for doing that.
I don't know whether you want to deal with your note first.
Would it be possible just to judge? I've got a note which may be, but I'm having difficulty just considering
Yes,
it's
yes.
just coming from my instructions. This is, it may be important.
Do you want us to rise for 5 minutes?
Would that be possible?
Yes, absolutely.
Could I just broach one thing again so that you can deal with it when we get back, which is, and I touched on it before, but I just need to be sure of your answer in relation to it, which is we discussed the fact that actually these 91 situations before the Ombudsman might have all sorts of facets to them, including change of position, etc. So they're not just very, very short, very simple issues necessarily. And I wasn't quite sure about your answer about why, therefore, there should be a different procedure under 91.6 than there is again in 1515 in relation to the enforcement of a determination or direction. And that's what the Pensions Ombudsman will give in a dispute which would fall under 91.6, and why, therefore, how we can justify, if it's necessary, two different regimes, in fact. And I think I know your answer, but I just like it on a postcard, please.
Have a think about it. Well, I'll say 11:30 on that clock.
Thank you.
Court rise if able.
What do you mean by well, you just told me that it's not because it's rubber stamped.
No, they have to go for an ombudsman. Why do they want to go for a whole ombudsman? It's an IDR. You could just go to an ombudsman process, then enforcement. They're saying that under the current wording, since the ombudsman's competent isn't competent or has no status, why don't we just cut out the ombudsman and go straight to court and get done with the equation?
The answer is the ombudsman, because the enforcement process isn't going to add anything. Yeah, they say, what does the enforcement process add to the complexity of an ombudsman determination? The High Court would have to spend huge amounts of money.
It doesn't have
to do it.
significant complexity of ombudsman. Or what it is pointing people away from it.
Yeah, but what else? You've just got to go out and tell them that's not a problem. That's going to say that's a complication issue.
But that's,
Well, why can't you?
that's the status of they clear that up. No one thinks we're competent court because that's sad. So they're talking about wishes.
That decision that the competent court is only needed to enforce it's going to the county court for enforcement. What's the type of the problem is that going to the county court for enforcement is, as you gave given that note, is going to cost 4 months. It's going to be done in 5 minutes. It's not going to involve the trustees in any of the money. The idea that they would be avoiding that and instead paying huge amounts of money going to court and huge amounts of time is barking.
Well, that's what we're doing now. Members of the union arguing that they shouldn't have to get any paid in.
I'm not going to be able to persuade them.
Yeah.
That's sufficient. That's sufficient to deal with this. But do you see the? Do you see what? Yeah.
It's not what our instructions are not. We don't have to have that. We have to send the determination to time. It's the concern is the status of this issue hasn't been away. It's people who say that it doesn't need away.
So that would be a step forward.
Oh no, they realise it's the trustees that are doing it. Yeah, we're not. We don't enforce. We're the tribunal. We're not the party that needs to have enforcement.
I thought there was a little bit to that.
Why we're here.
Status. What's
think they want to know why we're here.
Yeah.
I can say this.
I thought editing was enforced. What's the problem if it doesn't get enforced? And that goes on.
I'm happy to say this to explain why it is we're here. What we're not going to do is to get them to change their mind because of this point.
Yeah.
I didn't even answer the question.
The point she was making was, if there are lots of things like defence that can argue, why should we have a different path to enforcement? I think the answer was, those will still be appealed. So there isn't anybody who's got different questions, still the right to appeal. But we're still saying that if we are determined the right to
She says she never got my answers to me. I wish I had told her. She's saying this is the general rule. Then why are we saying that there's a kind of special power for these cases that means that you're not in that, you have to go to court. And I think the answer is because this is not about, I don't think this is a provision which tells you whether the pension ombudsman decision is enforceable in the sense of being an effective decision. You get that from the final binding provision. What the final binding is talking about is powers of enforcement. In other words, it is enforceable in the county court as if it were a judgment of order. It's not saying it is not an effective decision until you get the county court to understand. What it's saying is, in addition to the pension ombudsman having the powers that it has, it can also invoke the ancillary jurisdiction of the county court to help it by making orders which it doesn't have to carry out. How does that answer satisfy? Because in our case, there's no enforcement required. If section 1515 is telling you, in addition to its own powers, it can invoke the county court's enforcement powers in a case where enforcement is required. So my concern is that the Chancellor in particular thinks that this requires to enforce it in the sense of valid and effective rather than
I think
to be enforced by an
I think she's
injunction.
concerned about the decision making that we take on the GP position. Is that, how is that backed up?
This is when it says shall be enforced, doesn't mean it is not an effective decision intent. It means if you need orders which coerce people to do things, you can, the PO has not been given the power to make those sorts of orders, but it can get the county court to make them, and you don't have to re-argue the merits because it's just, but the reason why this is, they really think that? I really think that.
I think she thought that if she was doing any decisions from changing position, she was concerned about the extra protection and the legal. But they had the protection. She was buying that anyway on and appeal. I think she's not quite listening.
Then just as with was very keen on this idea that it's enough, just the determination is enforceable as if it's been through court, and that then feeds into 1906. And you say, well, it's a fiction. It's a fiction. I don't think they need to do this. She's not. She's slightly in a fact. I think honestly, I'm not the one she wants to go to something that she's. I also can't see the clock the Chancellor was referring to. He said 1:30 on this clock. You know that clock?
These types of decisions.
There we go. It's a tricky clock.
She won't be enforcing everything else.
I've got all these notes to
According to this category.
But I'm not sure their understanding about the level of enforcement. I mean, there just isn't any enforcement in most cases. And in this case, where you're enforcing allocation. I think that's what I was concerned about,
I do feel like
It's really important to remember that the dispute is like the entire IDRP process and the PO process. That's what really what the dispute is that entire period.
Yes.
Until the PO decides it.
I think you can understand
And just in relation to what the obligation is, our answer to the obligation to pay the money, which is different from the treatment, which is the method by which. So I think it's ready. I think we've got to keep an eye on everything.
basically introducing a compulsory enforcement process. Yeah.
Court rise if able.
Yes.
If I could deal with my lady Justice Asplin's issue first. The difference between our situation here in respect to recoupment, where the dispute is to amount, and the wider situation where there are more issues, is that in the recoupment situation, there is no need to enforce. Whereas in other situations, there may be a need to enforce. And this gives rise just to a point we wanted to make clear as to the difference between when the determination is valid and effective and what the consequences are for enforcement. In our submission, the determination is valid and effective once the determination is made. That's the effect of section 1513. It's final and binding on the parties. Section 1515 only arises if in this situation the trustees need the additional powers of the county court to enforce the directions in the determination.
Well, that's obviously right. That you could have a scenario where the trustee says, I've overpaid you 45% or whatever it is, and the members say, fine. You don't need anything you don't need to have a court order of any description. It's only surely if for whatever reason the members, there has to be enforcement of one kind or another, that any of this arises. But the problem with that argument you've just elucidated is section 91.6 talks about the set-off. It's not just charges and liens, it's set-off,
Yes.
which is a right of self-help.
Yes.
Must not be exercised. So there is a need to enforce, because you can't exercise the right unless you've gone through the relevant hoop. So you come back to the same point, I think.
Well, if it's but perhaps what this is more relevant to is the dispute point.
Well, it's only none of this arises unless there is a dispute.
Quite. And perhaps I just wanted to make sure I'd answered my lady Justice Aspin's question. But perhaps, and I don't want to start repeating myself, but perhaps the relevance of this is that section 1513 is the answer to section 91.6 without having to get into the question of competent court and why section 91.6, how the interaction between section 91.6 and section 1515. You don't get into that. And I've given the reasons to the court as to why, in our submission, that's consistent with policy.
And that's your no dispute argument.
Yes, it's our no dispute argument. The other point, and I'm grateful for the court's indulgence, that I just want to take instructions on, was just to get clear in my mind for my instructing solicitors as to why we're here.
Yes, it's always a good idea.
Yes. Well, I've already talked about the concerns about the status of determinations notwithstanding section 1513, and I've identified that the trustee in this case doesn't accept and has put forward an argument that res judicata doesn't apply. And if we get nothing out of this other than your lordship's confirmation that res judicata does apply, then that will obviously be extremely helpful as far as that's concerned. But the particular concern that's been addressed to me by my instructing solicitors is that trustees have expressed concerns that they've got two choices when it comes to something like a recoupment situation, for example. They can either allow the member to make a complaint to the ombudsman and to go through the ombudsman route, or they could preempt that situation by applying to the High Court. And obviously, if they went through the High Court process, got an order of the High Court, that would no doubt satisfy section 91.6 requirement for an order of the competent court. And the concern trustees have said is that if they go through the ombudsman process and are then told the Ombudsman is not a competent court and have to go to another court, why don't they simply go to court in the first place and avoid the Ombudsman process altogether? Now, that's something which the Ombudsman is concerned not to happen, because obviously the expense involved in going to court, the delays involved in going to court, when I say court, I mean the High Court or the County Court, would far outweigh the costs and expense and the timing in respect of the going to the Ombudsman. And so that is a concern the Ombudsman has, and it's one that it has because trustees have raised that with the Ombudsman, having seen the BIC decision, having seen the first instance decision in this case, saying, well, if we're being told that the Ombudsman is not good enough, we've got to do something else as well. Well, why don't we do that? Why don't we just do that something else first?
Because you tell them the answer is never mind the competent court point, which seems to me to have become a complete red herring. You go and get your rubber stamp, and we've got this form, which we always send off to the county court, and the county court does the job. That means that the whole process, the Ombudsman process, is quicker, cheaper, and all the rest of it. I follow the point. They don't want to run the risk of somebody saying, "Well, I might just as well go to the High Court." But I can't. No trustee in his or her right mind is going to say, "Well, merely because there has to be a rubber stamp from the county court, I'd rather go through an expensive High Court process. Thank you very much."
All I'm saying is that's what the Ombudsman's concerns in that regard are ones that have been expressed to trustees. I accept your Lordship's point. It may ultimately be a matter of communication. It may be the communication will be eased by whatever we get from your Lordship, your Ladyships, but I just wanted to make it clear that that's why we're here.
Okay.
Unless I can assist your Lordship, your Ladyships any further, that's what we have to say for the moment.
Can you help me? I'm looking at the judgment of Mr. Justice Leach. Could you just help me where the questions are?
The questions are at the end, the ladies. If you go to
them in a single list. My question to you is, have we got the right questions, given where we are now, where we may be on this appeal? We're not really looking at competent court at all. We're looking at, or we may not be looking at competent court at all. We're looking at whether Section 91(6) is engaged at all, or how it fits in with Section 145.
Well, it's 991, isn't it? Page 145 of the bundle.
Yes.
Question 9.1
yes.
covers what we've been debating this morning, really, doesn't it?
Yeah.
Does
Is that under challenge in your appeal?
We have not appealed 9.1. We have raised now grounds of appeal in the alternative. The issue that is raised in 9.1. Would you like me just to show you where?
I've seen the bit in your skeleton that says in the alternative.
Yes, and it's in issue.
Get to Section 91.
And it's issue 9 of our grounds of appeal.
I'll look at this a bit overnight. I just want to be sure that we've got the
grounds of appeal, my lord, are tab 1. Is it?
I can't find them.
Page 18.
Thank you.
Yes, tab 1.
Page 18. Yeah, got you.
Thank you.
But they don't go to this.
And it's 9 on page 19.
Yeah. Okay.
But that's the no longer being a dispute point, yes.
Yes, yes. I think that was the point Lady Justice Whipple was concerned about, as to whether or not.
It's that, but it's just, to be honest, I haven't quite thought it through myself, and I haven't pondered at lunchtime, but just to make sure that we have in focus as part of this appeal the points that we've been discussing this morning about how Section 151 of the 93 Act plays in with Section 91(6) of the of the 95
Yes.
Act.
Yes. Is there anything I can help you with?
No, I mean, I just raise it. If everybody would just think about that, please. So we've got it technically.
Thank you very much, Mr. Newman.
Thank you, Rob.
Mr. Shaw.
My lord, my ladies, I have a note that says this appeal raises 2 short questions. Is the Pensions Ombudsman a court, and is it a competent court? Obviously the argument has moved on a little, and we'll also consider the exact meaning and operation of the relevant words in section 91(6). I will seek to address all of these questions really together, running through the history of this provision, which has been in force in more or less these terms since 1973. But I should observe at the outset that the trustee is here with a view to being helpful. The trustee brought the Part 8 proceedings because it wanted to know how to administer the scheme. It got answers, it was satisfied by them. And the Pensions Ombudsman sought to appeal. It needed someone to sit over here, and that's the role we're performing. It doesn't suggest that the Ombudsman has a particular dog in the fight at this stage. But if I can...
And your reasonable costs are being paid.
Our costs are certainly reasonable, they're being paid.
Yes.
I'm going to have a finding as to that effect. That would be helpful. I'm going to start off by asking the court to look at the Social Security Act 1973, which is in tab 8 of the bundle of authority, of the first bundle. And it's paragraph 17 of Schedule 16 of the 1973 Act, which deals with what's called preservation, i.e. deals with short service benefits. These are benefits owed to people who leave service before retirement. And the original statutory protection against claims being made in relation to short service benefits. In fact, so it's really paragraph 18, which is on page 146 of the bundle. Paragraph 18.1, so the scheme must contain no rule enabling a member's employer to exercise any description of charge, lien or set-off against short service benefit. But a charge, lien or set-off against member's short service benefit is permissible, ignoring transfer credits, for the purpose of enabling the employer to obtain the discharge by the member of some monetary obligation due to the employer and arising out of a criminal, negligent, fraudulent act, or it says commission, in fact that is omission. This is an error in the Westlaw printout. Omission by the member, and then at paragraph 2C, we see exactly the same form of words as are found now in section 91.6. And this is relatively straightforward. If there had been a criminal act, the member owed his or her employer £100. That sum could be the subject of a set-off, but only if the employer had an order from a competent court or an award from an arbitrator. And it's certainly the case that at this stage, it wasn't envisaged that the Pensions Ombudsman would deal with.
I mean, the reality is, I absolutely follow your point, and I agree it's the same provision, although in the modern version it's been changed in two respects. It says where there is a dispute, as opposed to in the event of any dispute, which is much more neutral as to whether the dispute is present or past, dealing with one of Mr. Newman's points. And also it's much clearer, except after the obligation has become enforceable, and much clearer words in emphasising that you have to have the order of the court before you do anything, than has become enforceable. So it's a classic example of changing something for the sake of it and it becoming less clear.
My lord, yes, I would say the current version, 91.6, in relation to arbitrators' awards, does make that clear, because it says in consequence of an arbitrator's award. But I'll come back to 91 in due course. But at this, when section 70, when paragraph 18 came into force, 1973, there was no question of this being anything at all to do with the Ombudsman, because the Ombudsman didn't exist. When the Ombudsman did come into being, and this was as a result of the Social Security Act, that's wrong, Social Security Act 1990, which introduced the provisions relating to the Ombudsman into the Social Security and Pensions Act 1975, and that's at the next tab, tab 9, the Ombudsman still wouldn't have been able to make that type of order, and I'll explain why that is. And although these provisions are largely historic and have been replaced in the Pension Schemes Act 1993, when the Pension Schemes Act 1993 was first made, the provisions dealing with the Pensions Ombudsman were very much in this form. They were amended later following the Good Report, but the original 93 version of the Pensions Ombudsman legislation was in this form. And there are some points that aren't materially different, although they are more straightforward. And the first of those is seen at section 59C, the functions of the Pensions Ombudsman. And this has been reformulated in the current legislation to deal with the broadening of the Ombudsman's function in 1997. But the essential point is that at this stage, the Ombudsman could only investigate matters where the complaint was made by the member. And that's apparent from subsections 1 and 2. So even if there was a dispute of fact or law between the trustees and an authorised complainant, the Ombudsman could only investigate that if it had been referred to him by the authorised complainant, by the member. I'll also just refer briefly subsection 5, 5A, which makes clear that the Pensions Ombudsman shall not investigate or determine a complaint or dispute if before the making of the complaint or the reference of the dispute, proceedings have been commenced in any court in respect of matters which will be the subject of the investigation. I'll come back to that later, but rather than having to jump around. Now, that's what the Ombudsman can investigate, but if I can ask you to turn to page 159, and that's section 59H. This is now.
You see at 5 the same provision as in section 151.5 of the 19.
My lord, yeah, there may be some linguistic changes, but the essence is the same.
Yeah.
But I want to emphasise the following points. Where the Pensions Ombudsman has conducted an investigation under this part of the Act, send a written statement of his determination of the complaint or dispute in question to the complainant, to the managers, and any such statement shall contain the reasons for his determination. And in my submission, there is a difference between the determination and the reasons for the determination. And that's important, I say, because it's not the effect of section 151 now, section 59H then, that anything that's said in the course of the reasons is the determination and can be enforced. What can be done is set out in subsection 2, again, there's a parallel in section 151, but where a determination is made, what the Ombudsman can do is to direct the trustees or managers of the scheme to take or refrain from taking such steps as he may specify in the statement referred to in subsection 1, above or otherwise in writing. in fact, that wording's changed now. So rather than trustees and managers, it says person responsible for the management of the scheme. But the gist is the same. A direction cannot be made requiring a member to do anything, and nor can a direction be made permitting the trustees to do anything. All they can do, or all a direction can do, is say the trustee must do X, must do Y. And that is what is enforced under the enforcement regime. Now, the enforcement regulations are in the bundle at tab 17. I think these are still in bundle number 1. And these are the only ones that have ever been made, so far as I can identify. So they've been preserved, not only when the Acts, the Pensions Ombudsman goes forward, but they even refer to the county court rules. But they've been retained, presumably, by the transitional provisions. But this is the current law in force in relation to enforcement. And Rule 2, I think this is the basis for the explanation my lords, my ladies were given earlier. So subject to paragraph 2, whenever the pension ombudsman directs the payment of money, county court rules concerning the enforcement of payment of judgment debt shall apply to the direction as if it were a county court judgment. And then at 2, the direction issued by the pensions ombudsman for the payment of money shall not be enforced, whether by issue of a warrant, execution or otherwise, unless the applicant for enforcement has filed with his application a copy of the direction certified by the pensions ombudsman to be a true copy of the original. So that's what can be done. You can get a true copy of the direction, file that with the court, and then it can be executed as if it were an order of the court.
So it becomes just like a money judgment, a county court judgment.
Yes.
It's an IOU, and you just follow the track of county court enforcements.
Yes, yes,
For money judgments.
yes. That's for a direction to pay money. But of course, directions can go beyond that, and there can be a direction to take or refrain from taking any step, dealt with in Rule 3, and it's exactly the same, but not dealing with money payment. So whenever the pension ombudsman directs a person to take or refrain from taking any step, county court rules concerning enforcement of judgment, in particular Order 29, committal for breach, shall apply, but again with the same requirement for a copy, a certified copy of the direction to be provided. And if we turn down, there are the signatures, and that's the end of the enforcement regulations. Because what is enforced are the directions saying you must do this, and those directions only ever require, for our purposes, the trustee to do something, or as the law's moved on, the employer to do something. They cannot ever require a member to do something. And I say that's important because one just needs to consider what the position would be if there was a judgment of the court, county court or the High Court. Because let's say a member has been told, well, we're going to start deducting money from your pension payments because you owe us money because of a fraudulent breach of contract. So that's not dealing with the overpayment case, that's dealing with the law as it was in 1990. And the judgment or the reasons, if the member brings a claim either asking for a declaration or seeking payment of anything that's been underpaid, the judgment might observe that the member did in fact owe the scheme or the employer £100 because of a breach of contract that was fraudulent. But that might be mentioned in the judgment because the defendant, the trustee or the employer, had sought to justify its behaviour by reference to that debt. But unless there was a counterclaim and an order requiring payment of that £100, the employer could not take the judgment as a whole into the enforcement office and say, look at paragraph 27, it says there, he owes me £100. It's only if you have an order that says that. Now, if that's the position with the county court or the high court, in my submission, it would be odd if a more generous approach was taken to the reasoning of the pensions ombudsman when it isn't reduced into the order itself, which is effectively and certainly a direction, or at most the decision that the complaint is upheld or the complaint is not upheld. In my submission, the section 91(6) certainly doesn't contemplate simply allowing anything said by the Ombudsman in the course of his decision to be enforced as if it was an order. Now,
can I just reel back a bit? The current provision, section 151, so the Ombudsman can give a determination and can give directions. Yes. So is the target of your submissions that if the Ombudsman gives directions about X shall pay Y or set off or whatever, that's the sort of, that's akin to an order. That's the sort of thing that feeds into this enforcement process.
yes, that's
So
right.
the Ombudsman makes the determination that the members have been overpaid here because in fact the forfeiture provision should have been applied. So he makes that determination. So that's the determination under section 151 subsection 1, which he gives a written statement of that determination to the members, because they're the person who made the complaint in the first place to the Pensions Ombudsman. And then where he makes that determination under 2, he may direct the trustee here or the employer to take or refrain from taking any steps. He doesn't need to do that here because it's a determination that there's been an overpayment to the members. And then under subsection 5 of section 151, that determination of the Pensions Ombudsman is enforceable as if in the county court, as if it were a judgment or order of the county court. And according to the statutes as it currently stands in section 151, that doesn't say shall be enforceable by the member. It could be enforceable by anybody, including the trustee.
Well, I was taking that in stages. The starting point, which is what is the determination and what are the reasons for the determination, is exactly the same. And when this phrasing was initially adopted, it was only, in my opinion, exclusively aimed at an order for payment. Because in 1973, until 2005, there was no reference to overpayments. It only applied where there were monies owed to the employer, and then from 1977 onwards, monies owed to the scheme as a result of criminal behaviour, negligence. In the case of someone who was a trustee as well as a member, there was a specific provision for breach of trust, so they could be ordered to pay money. But throughout that period, the first 20 odd years of this provision existing in substance, it only envisaged the requirement for an order being satisfied by an order that said the member has to pay some money.
Well, that's no doubt very interesting statutory archaeology, but we're concerned with the sections as they now stand, which is as they've stood since 2014, which include determinations by the Pensions Ombudsman that there's been an overpayment.
Well, my lord, perhaps if I can run through the archaeology, bring us up to the current date,
Yeah.
then I'll deal straight on with that issue, because Section 70, sorry, the 1973 Act was then replicated in Section 79 of the Pension Schemes Act 1993. Your Lordship has that at tab 13 of the bundle, page 195, where effectively the same wording. So at this stage, the orders anticipated in subsection 4, paragraph C, in my submission, were plainly in order for payment.
Sorry, so this is charges lien set off.
Yes, this is the equivalent to paragraph 18 of the schedule to the 1973 Act, which is then repeated in the 93 Act, but again limited to short service benefits. And it was as a result of the suggestions of the Good Report, that's the Pension Law Review Committee in 1993, that extended the coverage of what was Section 79 into the whole of benefits, not just short service benefits, and that produced Section 91. And so Section 91, as it came into force, was intended to operate in the same way, albeit to a wider range of benefits. And so when this is back in tab number 2, when first made, this section only included, insofar as material, under subsection 5, paragraphs D and D. Included A, B, C too, but only included D and E. There was no reference at all to overpayments. That was introduced 10 years later in 2005. So as made, subsection 6 applied to the same situations, i.e. situations where the member owed money to the employer or the scheme because of an act of negligence or fraud. And that could only be dealt with, or that could only result in a set-off in the event of a dispute, where the monetary obligation in question has become enforceable under an order of a competent court.
That's owed money to the employer or the scheme.
Yes, I jump. Perhaps I should have taken it more slowly. But if one looks at subsection E, it refers to a charge lien or set-off against the person in question's entitlement, right, for the purpose of discharging some monetary obligation due from the person in question to the scheme.
And D is employer.
And D is the employer. It's a slightly broader, something slightly broader in E, because your ladyship will see at Roman numeral 2 that deals with the question of where the member is also a trustee of the scheme is in breach of trust. But these were all envisaging orders being made enforcing a monetary obligation. And although the Ombudsman could deal with these matters, could deal with fraud, that's the Whipple decision referred to by my learned friend in his skeleton, I think. The
It was a
Ombudsman...
monetary obligation that could arise by way of set-off. But from the very outset of the legislation, it could arise by way of set-off.
Yes.
So in other words, the trustee could set off against sums otherwise due to the member.
Yes. Notwithstanding, the member wouldn't need to do anything, or it being seen as a passive event. So it was intended to govern that situation, intended to govern the situation of set-off, but simply could not be achieved via the Ombudsman, because even if in the course of his decision he said, I agree that the trustee was in breach of trust. Actually, trustee is a very bad example. I agree that the member stole from the employer and owes them £100. He could not make the monetary obligation on the member to repay that £100 enforceable. Something else would have to be done. There would need to be.
What's now section 1515, that would be done by going to the county court and getting an order from the county court enforcing the decision that the member owes £100.
In my submission, that's not possible. The enforcement regime in the county court involves enforcing directions for payment, because the Ombudsman has no power.
That's the point, it's lopsided at this stage,
Yes.
is it? The Ombudsman can only give directions to the trustee
Yes.
or the employer.
Yes, and it would entirely negate that safety mechanism, that lopsided approach for the benefit of the complainants, if you simply ignored that and said, well, the Ombudsman can actually say whatever he wants in his reasons and then they can be enforced. So at that stage in my submission, it could not have been argued that the Ombudsman saying something in the course of his examination of the question of fraud made the monetary obligation on the member enforceable.
So you couldn't make it enforceable on the member because you're taking us back to 151.
Yeah.
For example, at 2, he may direct that let's just cut it short, the trustee takes or refrains from taking a step.
Yes.
But he can't direct that the member is liable or owes a sum.
Yes, yes. Now there is one caveat to that, which is where the member is a trustee as well.
Yes, but
That trustee member can be ordered to pay money.
Mhm.
That's direction that can be enforced. In those circumstances, there's no problem. But as things stood before the 2005 amendment introducing overpayments, in my submission it would have been tolerably clear that the Ombudsman could not provide an order making the monetary obligation enforceable, and couldn't do it directly and couldn't do it indirectly by the county court simply rubber stamping a paragraph.
But those county court enforcement directions or rules that you drew to our attention at tab 17 include in rule 2 that contemplates enforcement where the pensions ombudsman directs the payment of money.
Yes.
Where is that dealt with in your regime, if I can put it that way?
but that direction
For the payment of money.
for the payment of money can only be made under section 1512, and that's at page 24 of the bundle of authorities in the first tab.
Yeah, because that's dealing with directions to take or refrain from taking steps.
Yes.
As may be specified, and that's dealt with by Rule 3.
Yes. But
in
that,
the enforcement
my lord,
rules.
one of the steps that the Ombudsman can direct someone to take is to pay money.
Dealing with the direction for payment of money.
But in my submission, the ability to direct people to do something includes the ability to direct them to pay money, because otherwise I think the Ombudsman's been directing a lot of people to do that over the years. And unless, I'm not aware, unless someone can identify another provision, there's never been, I don't think, a separate ability to direct them to pay money. That's the.
So on that basis, in fact, looking back to tab 17, it would seem that Rule 2 really is OTOs, and you would always work under Rule 3, which is take or refrain from taking a step, which would be the Pensions Ombudsman has directed that you take the step to pay, and therefore you use Rule 3. That's what you're saying, is it?
My lady, no. I'm saying these are simply, the differences are really the enforcement mechanism. So where they're saying, where the Pension Ombudsman has directed someone to pay money, which I say he can do under subsection 2.
Yeah, well, yes, you say he can do that under subsection 2 because he can order or direct one to take a step.
Yes.
But if one is directing a person to take a step, you don't need Rule 2, you can just use Rule 3, is what I'm saying.
Well, my lady, if it's simply for the payment of money, you couldn't, for example, use committal proceedings in the county court. It's just a debt, and that's how it's recovered. But in any event, the power to direct is limited to the power to direct trustees and employers and certain others to take steps. There is no power to direct the member to do anything. There is no power to permit the trustee to do something. So in these overpayment cases, for example, the Ombudsman could not direct the trustee to recover an overpayment because it's still a matter for the trustee to decide whether or not it wants to do that. So, again, before the amendment introducing overpayments, there was simply no means by which the Ombudsman could directly or indirectly provide the order making the monetary obligation arising from the fraud or negligence or breach of trust. So not breach of trust, fraud or negligence or criminal behaviour enforceable. So it's entirely outside the scope of that provision. Now, this becomes an issue after the 2005 amendment when paragraph F was added to section 91. Now, this is going back, if I may, I'm sorry to jump around, going back to tab 2 and the Pensions Act 1995. And what is immediately apparent when F was introduced, I think it's the footnote.
2004.
Yeah, Pension Act 2004 with effect from April 2005. The language models itself on the language in D&E. So it refers to there being a charge or set off against the person in question's entitlement or right for the purpose of discharging some monetary obligation due from the person in question to the scheme arising out of a payment made in error. Now, it's common ground before, it's not challenged, that was intended to deal with these situations. We put the explanatory note in the skeleton argument. There's no doubt this was intended to cover the position where a scheme overpays and then seeks to recover.
Yeah.
Now, in these circumstances, subject to a change of position defence, there will be an obligation on the member to repay the money paid by mistake. So if someone has been overpaid £100 and they've no change of position or other relevant defence, they would be under a monetary obligation to repay that money. And the trustee could go to court and say, we don't want to set off, we want an order for that £100 to be paid back. There are various reasons why they don't want to do that, one of which is cost, one of which is limitation. But the practice of recoupment does have a theoretical justification that says we aren't actually asking the member to pay us back out of his pension. What we're doing is saying he's already had his pension, he's just had some of it early. And that's the theoretical justification that says this isn't requiring the member to make payments.
Which is why the recoupment, why they can recoup notwithstanding that more than 6 years has passed.
That's right, my lord, yes.
Because it's an exercise of a right of self-help.
Yes, but it's more than it's just a right of self-help. It's a right that depends on an analysis that says we're not taking money off you, we've already paid you.
Prepaid it.
And that's that. But notwithstanding that analysis, because the subsection F is based on the previous subsections D and E, tracks the language used in those sections entirely, some meaning still has to be given to the words monetary obligation and enforce the monetary obligation. And it's simply not enough to say, well, actually we're not enforcing anything because we have a right to self-help, because that's not how the arrangement or the position is analysed in section 91. Section 91 does refer to the monetary obligation, which is still there, even if the particular self-help remedy doesn't depend upon it. And then subsection 6 has the same language, unchanged, and I say unchanged in meaning, which is where there's a dispute, ignoring the first word, the set-off must not be exercised until the obligation in question has become enforceable under an order of a competent court or in consequence of an award by an arbitrator. So, in my submission, the meaning of that subsection hasn't changed by the introduction of subsection 5F. You still need an order making that obligation enforceable.
So
Now,
your point is that none of this actually involves the pension ombudsman at all?
save that, if you have a trustee who's also a member who's been in breach of trust,
No, I follow that point.
he
but
can make an order.
Not the present case.
But in cases of overpayment, even with the trustee who's also a member, the fact that in the reasoning, or the reasons that go with his determination, he has said you owe this money, or there is an overpayment, or even there is an overpayment, it can be recovered. And I'm going to come back in due course to exactly what would need to be said for my learned friend's argument to get off the ground. But whatever the Ombudsman does, it isn't providing an order that makes that monetary obligation enforceable. It doesn't provide a declaration that it's enforceable. And for the reasons I've sought to explain, someone simply couldn't go to the county court and say, look at paragraph 18 of the decision. It says there was an overpayment of £100. Please make a declaration or make an order confirming that to be the case. It might be helpful just briefly to look at a decision of the Ombudsman. I know certainly my Lady Justice Asplin is very familiar with them, but tab 32, this is in the second bundle. Say, insofar as I can, this is more or less chosen at random, other than I sought to choose one where the complaint was upheld to some extent, so that there's a direction, and it's got nothing at all to do with overpayments. So there was a cleaner example. I expected actually when I went through this exercise to have something that said determination at the top and reasons underneath. It doesn't do any of that. It talks about a judgment, and then it has outcome, which is effectively, I say that's the determination, and then underneath it, for the purposes of section 151, are the reasons. And the reasons are given in great detail.
Where are you reading from?
I'm sorry, my lord, just from the first page, which is at page 552.
Yeah.
You'll see the judgment, and the outcome is paragraph 1, and then the rest of it is, in my submission, are the reasons until we get down to perhaps paragraph 47, which says I partially uphold the complaint, and then the direction is made at the end there. And it would be, in my submission, that's straightforward. You can see what has happened, and you know what the direction is. And if the trustees didn't pay £500, they could, the complainant can go to the county court and enforce it under the regulations that we've seen. It's very unsatisfactory in my submission for the reasons to be enforced in the same way, because this is such an informal procedure. It may be that the member has simply complained that they're proposing to make a deduction, but they haven't explained why. Now, that complaint could result in the Ombudsman taking a view as to whether there was an overpayment or not. But the member may not have been seeking to challenge that, but it might be mentioned in the reasons. The member may or may not know or raise any change of position defence. And it is, in my submission, very unsatisfactory for the question of enforcement to depend upon exactly what's said in narrative reasons, which may or may not arise from a specific issue raised by one of the parties.
But are you not trying to blur, Mr. Short, reasons and determination? I can quite see you've put directions in a separate box, and you've shown us an example where there were directions and a decision. But the determination might it, and I'm just thinking aloud, it might be there has been an overpayment here of X pounds, and the trustee is entitled, should it think fit, to recoup that sum from future pension payments at the rate of X% per annum or whatever. Now, that would be not a direction, it's not directing them to do something, but it would be a determination.
Well, my lady,
And then how is that enforced? You're saying it's not enforced at all?
yes, my lady, but I am, I suppose, trying to blur the line between determination and reasons, because, but in my defence, I would say that's because there isn't a sharp line between them.
But if there's no sharp line, what does 151 mean?
Or putting it in concrete terms, take my lady's example. How do you address that in terms of the statute regime for enforcement? So you've got a determination by the pensions ombudsman that there's been an overpayment of X, and that the trustee is entitled to recoup X from the monies otherwise payable to the members. How does that fit into, in terms of, as it were, enforcement? I mean, that determination is final and binding, because that's what the statute says. So on the face of it, would give rise to a res judicata. How's it going to be enforced?
Well, my lord, on the basis that is a determination, and I am going to come back to that in a moment, you then move on to the question of whether it's an order of a competent court. And for the reasons that were set out in my skeleton, I say that the Ombudsman isn't court and isn't a competent court. But the determination is, I say, that is the decision either to uphold or not to uphold the complaint.
And so you say that what I've just described as reasons.
Part of the reasons for not upholding the complaint.
And so you say, just so I've got it clear, that what I've just described is not something that then falls within 151 subsection 5 at all, and can't be enforced at all.
That's right.
So what's the determination then? The determination is...
A determination would be, for example, a decision that there has been maladministration and a decision there has been maladministration. But
how does that fit in? If that is a decision and a determination, then it has no legs when you get to 1515. It's a determination that you can't enforce.
Yeah, well, unless
unless
it's accompanied by a direction, you don't enforce it.
That's not what the subsection
Not what it says.
It says any determination or direction.
Yes.
And I put the point to you earlier on that that subsection, section 1515, is completely neutral as to whether the determination is in favour of the trustee or in favour of the member. So in our example that we've been putting to you, why isn't the however you describe it, decision or whatever of the Ombudsman that says the members have been overpaid and the trustee is entitled to recoup, why isn't that a determination to that effect, which is enforceable under section 1515?
Well, my lord, because it is not an order that makes the monetary obligation.
That's not the point. It's a determination by the Pensions Ombudsman. And the statute, I mean, never mind what the rules say, but the statute says that it's enforceable in the county court as if it were a judgment of the county court.
Well, my lord, taking that in stages, and I'm going to start with section 91(6), it's not an order of a competent court that makes the monetary obligation enforceable, because for the reasons I've sought to explain, one could not take those reasons
Well,
to the
I
county
think we're at
court.
cross purposes with respect, Mr. Shaw. Speak for myself. I don't think that the Pensions Ombudsman is a competent court for all sorts of reasons. But what I think my lady and I were just putting to you was a different point, which is the point about enforcement of a decision, of a determination by the Pensions Ombudsman. So forget whether it's a competent court or not. Let's assume it isn't. You've got section 151 subsection 5, which says that determination is enforceable by following a particular procedure.
Yeah.
And I was simply questioning why that subsection doesn't apply to the determination that there's been an overpayment and that the trustee is entitled to recoup.
But my lord, I see it doesn't apply to the part of the document that comes out explaining that, because I do say that is part of the reasons rather than the determination. The determination is win-lose, and that's the only thing.
But that can't be right, Mr. Shaw, can it? In the light of section 1515, because if determination is restricted to win-lose and everything else is reasons which is unenforceable, then the reference to determination as well as direction in section 1515 is written water, means nothing. I mean, how can you enforce a win-lose if that is a determination?
Well,
What is it? You
my,
can't.
my lady, the enforcement mechanism, which is set out in the County Court Pensions Ombudsman Enforcement of Directions and Determinations Order, that's the what's expressed, is in fact limited. That's tab 17. It is just limited to what is directed by the Ombudsman. And I say that's no different from the position with any court. I'm unless invited to do other, I'm probably going to stop after this because I think I'm making the same point. But if the High Court or the County Court gives a judgment and the judgment has various conclusions in it, including, my lady, that one, including a finding that someone had been overpaid and is due to pay the money back. Unless that is incorporated into the order, the judgment, the narrative judgment, can't be enforced.
So you say, as a result of the order, a determination that there has been an overpayment of X and it may be recouped over a particular period at a particular rate, would only, you'd say that that's not a determination at all. But if it were, are you also saying that that would only translate into a declaration, and the order at tab 17 doesn't cover declarations?
Yes.
Is that also what you're saying?
My lady, it is that the Ombudsman has no power to grant declarations, including in particular declarations against the interests of the members or against the interests of the complainant. And I also come back to the point, even if it is a determination, it's still not an order of a competent court that makes a monetary obligation enforceable. So coming back after, even if I'm wrong about that, you still don't have an order of a competent court making the monetary obligation enforceable, which was the point where I'd intended to start my submissions.
And why isn't it covered by Rule 3 of the County Court rules? Because you'd have the Pensions Ombudsman, because you'd say it's not a direction,
It's not a
it's only a
direction.
permission.
Yes.
That's the highest they could put it. They could say you, the trustee, would be entitled to deduct £50 a month for the next 10 years.
Yes. But they can't get an order from the county court saying, actually, sorry, stepping back a little, the Ombudsman might say, well, you've been overpaid by £100, you don't have a change of position defence, you're liable to repay that £100, and I find that it would be reasonable for the trustee to recoup it at £10 a week. Now there you have a decision from the Ombudsman that says you owe £100, but you couldn't take that to the county court and say, look, they owe me £100. I want a payment of £100. That's the underlying monetary obligation.
I mean, I think your essential submission is that so far as overpayment and recoupment are concerned, it's outside the remit of the pension ombudsman altogether.
That's what he's saying.
Is that right?
No, my lord. Because what I'm saying is that the member...
If you think about it, given that the trustee can't make a reference to the pensions ombudsman, it's only the member, the cases in which it's likely to occur are going to be ones where the member, where perhaps the trustee's already indicated what he's proposing to do, and the member disputes it and then goes to the pensions ombudsman. The pensions ombudsman carries out an investigation and then makes a determination that in fact there has been an overpayment and that there is an entitlement to recoup. But that's all within the pensions ombudsman's remit, is it?
Yeah, the member is entitled to go to the pensions ombudsman and say...
But if it's all within the pensions ombudsman's remit, it's a pretty odd situation where that determination is incapable of being enforced by the route under section 1515, whereas if it's a determination in favour of the member that says the trustee's to pay him money, it somehow is.
Well,
I don't understand the point of it.
My lord, it would be an odd position if the ombudsman was intended to be a balanced tribunal, in the sense that it was one where the trustee or the member can complain.
Well, I understand.
But a decision has been taken that only the member can complain. So the member complains, they may get a decision that the overpayment, or there wasn't an overpayment, or that it can't be recouped at £10 a week, it should be £5 a week, or it would, there was a change of position defence. But it can only do that to improve the position of the member. It's not intended to act against the member's interests, and it would be an oddity if a member ends up in a worse position by going to the ombudsman than not going to the ombudsman.
But in that case, you were saying the ombudsman might decide it can only be recouped, for example, at £5 per month or whatever. Now, you would still say, and that would be, you would say, advantageous to the member. He might also have decided that it could be recouped at a greater amount. He's not prevented from deciding something which is contrary to the interest of the member once he's seized of the issue. He could say, no, actually, they can recoup at a greater rate than what you want. Now, in those circumstances, that is not in the interest of the member, but it is determining the dispute. He's not limited by always doing, something beneficial to the member. But you're saying that nevertheless, that decision about the rate of recoupment cannot be enforced.
I'm saying...
Is what you're saying?
My lady, yes, but it rather depends what you mean by enforced. So if the...
Because it's pointless. It's pointless for everybody. It's pointless for the member too. It's just written water. It's a waste of time. And that can't have been intended.
But my lady, in practical terms, it isn't. Because in many cases, once we get to that position, the members might say, OK, now it's all been explained to me, that's fine. I don't dispute it anymore, in which case it has worked. But section 91(6) still requires an order from a competent court making the monetary obligation, which is the obligation to repay, enforceable.
Well, let's take it in stages. You've accepted in answer to me that that it's within the remit of the Pensions Ombudsman to make a determination that there has been an overpayment to the members and it should be recouped at a certain rate.
Oh, my Lord, then I misspoke. Certainly within the scope of the Ombudsman's function to consider that, I am not accepting that everything said in the course of the reasons.
No, but he makes a determination. That's what he says at the end of his reasons. He says, and I determined that. So that's a determination. That's final and binding under section 1513. So then you go to court and you say to the court, the trustee says to the court, I've got this determination from the Pensions Ombudsman, which is final and binding, which says there's been overpayment of X and it's to be recouped at such and such a rate. And the court says, here's an order.
Oh, my Lord, if that happens by proceedings in the county court, then yes, there's an order that says the monetary
What I don't
obligation
understand
be
at the moment is
enforced.
what you say, what else could happen? I mean, are you saying that in that example, the members could still say to the court, oh, well, never mind all that. In fact, none of this is final and binding at all. We can re-litigate the whole thing.
No, we can't relitigate the same issues.
No.
But if an issue hadn't been considered, for example, the change of position defence, then it may be possible that that would be open to the member. It would depend on the exact nature of the decision reached.
Well, if it's been before the Pensions Ombudsman and they had the opportunity to raise it before the Pensions Ombudsman, then they're going to be stuck, aren't they, with arguments about issue of stoppable res judicata or abuse of process.
Well, it rather depends on the scope of the complaint that they've made. Because if they have just said this is maladministration, it wasn't explained to me properly, they've only raised that, and the Ombudsman in the course of his reasons says an overpayment had been made and there was no change in position defence, that might not be the same point. But
that wasn't what I think my Lord the Chancellor was referring to. He was referring to an actual determination, a conclusion, an express paragraph which says, and there was an overpayment of X which can be recouped at such and such a rate.
Yeah. Well,
there's no doubt, it's clear.
And if the members then pop up before the court and say, well, hang on a moment, we've actually we had a change of position defence, the court would say, well, why wasn't that raised before the Pensions Ombudsman?
my Lord, that's right. In the res judicata circumstances, they wouldn't be able to, if they.
I mean, I fully appreciate there might be certain circumstances in which they could raise something that they hadn't raised,
yes,
because it had only come to light since the determination by Pensions Ombudsman.
My Lord, exactly, and that's
principle that determination must be final and binding.
Yes, but my Lord, they would need to have some opportunity to do that, and it's simply not an administrative exercise because the enforcement regulations make clear that it's not seen as an administrative exercise once it goes past the question of directions that have been made. So there's no doubt at all, if there was
So just so that I'm clear, you're saying there is that paragraph which is crystal clear, and section 151 subsection 5 says a determination of the Ombudsman is enforced in the county court as it does, that nevertheless at that stage the county court will re-decide the issue?
My lady, I'm saying that if there's that paragraph,
Yeah.
paragraph 20,
A paragraph that's crystal clear.
crystal clear, in my submission, the trustee could not go to the court office in the county court and say, execute this or grant an order. There would have to be a judicial act. So they couldn't get that under the enforcement regulations. They could go to the county court and say, these issues have been conclusively determined in my favour. Please make an order declaring that to be the case. And in those circumstances, the member wouldn't be able to raise anything new unless there was some exceptional circumstance whereby they were not bound by res judicata. But there does need to be an order from the county court, because that's not dealt with administratively, because the administrative enforcement only takes place in relation to directions.
I have a difficulty with this proposition because I'm concerned that it undermines the purpose of little f in section 91. So 91, whatever it was, 5F, I think we agreed is here to meet the precise case where there's been an overpayment historically by the employer. And that is characterised in F as giving rise to a monetary obligation.
Yes.
You've said to us that there are arguments for and against that, but that's what the statute does. It says this is a monetary obligation. I think we're agreed that the member can complain about this and can take this to the pension ombudsman and say that's not fair. They're trying to take money out of my pension because they say I owe money historically. So that whole matter can go before the pension ombudsman.
Yes.
My concern is that I think somewhere along the line you say the pension ombudsman can make a determination and can give an indication about whether the money is due or not and whether it should be recouped or not, but that doesn't amount to a monetary obligation for the purposes of county court judgment for enforcement purposes. But that is inconsistent, isn't it? Because the statute's told us it's a monetary obligation, and there is a coherence in then feeding through the change in F and looking at it again in the context of section 151 sub 5 that talks about enforceability effectively of monetary obligations. I mean, that's the territory that we're in. So there is an inconsistency in what you're saying, isn't there? That you're having a monetary obligation for one purpose, but it doesn't, it sort of evaporates when you come to enforcement.
Well, my lady, I'm not trying to do that. In fact, I'm relying very much on the need for there to be a monetary obligation. Subsection 5F was introduced because it was suggested that overpayments, that the recovery of overpayments was impermissible as a result of subsection 91.1. So subsection 5, it provides a series of exceptions where you are allowed to set off. And in the case of overpayments, it has sought to regulate that by saying you are allowed to set off where there's been an overpayment to discharge the monetary obligation. Now, you may not need to rely on that for the purposes of recoupment, but there is a monetary obligation, and you
I would have thought it's very important. So
Yes.
it is a monetary obligation. It's real money.
Yes,
Because you've been
Take-
overpaid.
yes.
Just as in relation to D&E, albeit in different factual circumstances, the same point arises. There's
Yes.
a monetary obligation because there's too much money's been paid to the member.
That's right. And in all of these situations, it envisages the member owing the scheme £100 or whatever it is.
Yeah.
And so when one comes to 91.6, the order making that monetary obligation enforceable,
No, it's the set-off of that monetary obligation that needs to be enforceable. So it's the idea of, well, you know, it's the set-off. So it's not that any money has actually got to be paid by the member to the employer. It's that the member can have some of what he or she otherwise would be entitled to reduced by way of set-off.
Yeah, my lady, in my submission, section 91(6),
Yeah.
where it says set-off must not be exercised unless the obligation in question has become enforceable under an order of a competent court. That refers back to the monetary obligation referred to in F,
Yeah.
Yes.
which is the obligation to pay the £100.
Yes.
That's the obligation.
Yeah.
And so you need an order enforcing the obligation to pay £100. And the Pensions Ombudsman doesn't make that order enforcing the obligation to pay
No,
£100.
well, you're conflating two steps in one, I think, if I may say so,
Hello.
because where I think I'm struggling, where it may be the court is struggling, is the idea that the pension ombudsman, who is properly seized of this issue, may make a determination, let's just make it easy, saying, I determine that the member should have £100 deducted from their next quarterly payment.
Yes.
Nice, clear, direct determination. I take the point that they may not say, I direct the payer, the employer, to deduct £100. What section 151(5) says is that if the PO was to make a determination in those terms, as I read it, that would then be enforceable in the county court. It is enforceable as if it was a county court judgment. What's wrong with that? That's where I'm
yes.
falling apart.
Well, because, my lady, I say that the order of a competent court referred to in section 91(6) must be an order that's already been made, as was clear in the 73 Act and the 93 Act, where this provision came earlier, and also in the reference to the arbitrator, so it must be in consequence of an award. So you need the order of a competent court allowing you to enforce
So
it.
in my hypothesis, the PO has one line at the end that says, £100, member pays employer £100 should be deducted against next pension payment. Why can't that, using the mechanism in 1515, turn into an order? So that's a determination, direction of the Pensions Ombudsman.
Yeah.
Why is that not enforceable as if it were a judgment or order of the county court?
Well, it doesn't satisfy 196, even if it's an order. I say it's not an order that enforces the monetary obligation, because it doesn't say the member has to pay the money.
But the statute doesn't say that.
I see.
I mean, these enforcement rules may say that, but if the trustee turns up at the county court with section 1515 of the primary legislation and says this is what the primary legislation says, I'm entitled to an order from you, the county court, under this provision, because there's been a determination by the Pensions Ombudsman along the lines of what we've discussed, then the county court surely would have to make the order, wouldn't it? I mean, it wouldn't be able to turn around and say, oh, well, no, I'm terribly sorry. The delegated legislation that was passed 30 years ago has failed to catch up with the changes in the primary legislation, so out you go, you're not entitled to anything.
Yeah. Well, my lord, there have been no changes
I know.
in the
I've seen
primary
that.
legislation.
Well, there have been no changes in the delegated
There have been
legislation since 1993.
primary legislation. F is the change.
Oh,
Primary.
yes, my lady, yes, but there's been no changes no material
Sometimes, yeah.
changes to 91(6). But if an order is obtained from the county court saying you can, I don't know, saying whatever is necessary, so a declaration that says the trustee is entitled to recoup, that satisfies 91.6.
Yeah.
No doubt about that.
Yeah.
But it satisfies it because there is an order from
So
the
there's a
county.
determination by the Pensions Ombudsman, which is final and binding. He goes to the county court, gets an order from the county court to the same effect, and that then satisfies section 91.6.
My lord, it's if
I
an
can't see why it's not within your regulations, your old regulations, like your 1993 regulations, regulation 3, why it's not a direction for a person to take any step.
because directions can only be made against the trustee effectively to take a step. They cannot be made against a member to take a step.
No, but this is the trustee, I think we're going around in circles, isn't this the trustee taking some money off the pension?
Yes, they can't be ordered to do that. They can't be directed to do that. This is one thing that was raised in the Pensions Ombudsman's fact sheet. He said, well, I can make an order permitting the trustees to do that, but he has no power to do that. But if an order is made by the county court, then that is, on any basis, an order of a competent court.
And so, just so we have our very, very clear determination, which says member X owes £100, and it may be deducted by the trustee out of his next pension payment, and the trustee takes that to the county court. It's binding and final, and the county court makes a declaration in precisely the same terms. You accept then that falls within 91.6?
Absolutely, yes.
And there's no
yes.
need when the trustee goes to the court to do other than show the final and binding determination. I know we've said this so many times, but I just need to be clear that there's no further determination in a judicial capacity by the county court of the questions which have already been determined.
I know that is where I depart company.
Well, that's where I think you may be wobbling.
Yes. Well, I'm not, I might be wrong, but I'm not wobbling. I am definitely sticking with that, even if it's wrong, because that's the point. There, as soon as there's an order of the county court, there is an order enforcing the monetary obligation.
But the previous question, Mr. Short, what happens when the trustee goes with the determination? Is it a, thank you, I've seen the determination and therefore I am required to enforce it, and I enforce it by making a declaration, full stop? Because I don't think that's really what you're saying, but I just need to get there.
Subject to your point earlier about the members saying, well, we've got this change of position defence, which we didn't raise earlier,
and
we've got a jolly good reason for not raising it earlier. But subject to that...
No, I do agree, but what I think is important, though, is that has to be taken to the court office, and proceedings are required, and a judicial act is required.
Okay.
In my submission, it wouldn't be possible simply to go to the court office and ask for a member of staff to stamp the document.
So the difference between you is that it isn't just an enforcement stamp, administrative, but a judge or deputy judge or whatever in the county DJ and the county court has to say, aha, I see I have a final and binding determination of the Ombudsman, which says in paragraph X what it says. I accordingly, under section 1515, make a declaration in exactly the same terms. Full stop. And he would have no, this is setting aside, putting aside members saying points haven't been dealt with, etc. But he would actually have, to say that's a judicial act is, well, it is, but he he doesn't have any other discretion to do anything else other than to make the declaration in the form of the crisp paragraph of the Pensions Ombudsman's determination.
Well, depending upon the question of defences that can be
We're
made.
putting aside offences,
But
and
he-
we've got a very crisp
the
paragraph.
the district judge would have to follow the determination where that determination achieves a res judicata.
Yes.
Yeah.
But it's still a decision that has to be made, and it is not a purely administrative act done in the court office without any judicial decision. And the reason for that is that the determination by the Ombudsman isn't sufficient because in itself, because the Ombudsman isn't a court and is not a competent court for these purposes. And I might come back very briefly at the end, 1 o'clock, to the point that was actually the point in the appeal, but it's never been suggested that an order from the county court wouldn't be sufficient. An order from the county court is obviously an order of a competent court, but we say the order of the Pensions Ombudsman, or the determination of the Pensions Ombudsman, isn't. I'm not sure.
Although that's the subject of the appeal, we haven't really been addressed on it very much this morning.
No.
Let alone look at any authorities on the point. But let's say 2 o'clock. Thank you very much.
Court rise if able.